they pulled out a calendar and they scheduled out how they were going to get all of them done, and they did. And he cleared out a significant backlog. And I think if you are using effective calendar management as a judge to begin with, there is some room for these situations where, if at the 11th hour a continuance is required to ensure that the process is just, that due process is observed, you can do that. You can accommodate that. And really, if it comes down to a decision where, on one hand, the rights of the accused are being balanced against this larger principle that cases need to be dispositioned in a quicker manner, I'd be hard pressed to find, I don't want to say how I rule, because that's a violation of my obligations as a candidate here, but I would be hard pressed to imagine a scenario in which the overall bureaucratic time constraints of the court would win out over the rights of someone accused of a crime to get a fair trial, fair process.
Okay. What do you believe are the root causes for high numbers of juvenile offenders? What changes can the court system make to reduce these numbers?
For juveniles, to refer back to what I talked about before with the housing crisis in Santa Cruz County and the external pressures. And the housing crisis, that's just one. I think what I've seen firsthand working in juvenile, and it is alarming to me, and there needs to be some community-wide effort to address this, is that there is a phenomenon of children age 10, 11, 12, 13 being preyed upon by adult gang members and being recruited in at very early ages, being indoctrinated, being exposed to a way of life that I think from their perspective probably seems inevitable or hard to escape from. And as a community, Santa Cruz County, we have such tremendous resources. There is tremendous well care. There are incredible recreational opportunities, any kind of sport you could ever want to play. We have the ocean, we have the mountains, we have all of the kinds of activities that could be done there, and we have a very robust local nonprofit community. And I think that as a community we could get together and effectively create some interventions in these children's lives so that they're not being preyed upon and groomed the way that they are now, and prevent the next generation of gang members from graduating to committing crimes, to committing robberies, to committing homicides.
How would you respond if a party or institution, such as the Public Defender's Office or District Attorney's Office, threatened to disqualify you under Code of Civil Procedure Section 170.6 on all cases or all cases of a certain type due to a particular decision?
I'd schedule a vacation. My campaign materials, one of the words I use is integrity, and that's not just something I put up there because it sounds good or it looks good. At the end of this race and at the end of my career, I'm gonna be done, and I'm gonna be able to look back and know that my integrity is intact, and I'm gonna do what I think is right and consistent with my obligations in any kind of work that I do. And so, they can threaten me all they want. I'm gonna do what I think is right. And for the last 10 years, public defender, criminal defense attorneys, we're the voice of dissent in these courtrooms. And it's not always easy to be. It's under tremendous pressure, it's under tremendous scrutiny. You have law enforcement, you have district attorneys, you often have judges putting pressure on you to play ball, probably stating it too strongly. And what makes a good defense attorney, I think, is a quality that makes a good independent judge, and that is the ability to draw your line in the sand at the point where you know what is right and what is not right, and toe that line. And that's something that I've been doing for 10 years, and I will continue to do if I'm unsuccessful as a defense attorney, or I will continue to do on the bench as a judge.
How do you balance the rights of victims with the rights of criminal defendants? What drives this balance?
Well, California has a Marsy's Law, right, the Victims' Bill of Rights, and it details out certain rights and, that's what I'm looking for, not entitlements, certain protections that people that fall within the category of victims are entitled to during the process. And those are codified in the California Constitution, and they're important, and they're a way to ensure that people are being treated fairly, that people are not being harassed or threatened while they go through the process of being a witness or a victim of a crime. And I've defended lots of people. I've also been a crime victim myself. I've had property stolen from me. My father and his mother, when my dad was about 19, were kidnapped and held for ransom, and in a very kind of violent episode. So I'm sensitive to criminality, and I'm raising 3 children in this community, so I want it to be a safe and healthy community. But at the end of the day, your right to due process, your right to a fair trial, your right to competent counsel, those come from the United States Constitution. And a principle that we don't often deal with in criminal law is preemption, right? And so if there are those cases where there is tension, you have to look and do that analysis. And at the end of the day, while it's not easy to be a victim, it's not easy to be a witness, and oftentimes it's very traumatic, it's very personally challenging. The process in the criminal court is the state is saying we believe there is reason for the judge to restrict somebody's liberty, and that might be a fine, that might be community service, it might be the rest of your life in prison. And that's an incredible amount of power. It's incredibly serious, and that is the person who stands to lose at the end of the process. And so we need to always aspire to and ensure that that process is fair for the accused.
Outstanding.
Thank you.
Okay, that's the end of those 10 questions. Now, anybody have any questions they wish to ask? You follow up on these, different subjects. Hard to believe that you would have a question, Angel.
I know, isn't it amazing?
It is amazing.
I see Sigya's signs all over the place. I see her buttons all over the place. I see her materials all over the place. I assume you're busy in court. What concerns me is that the community doesn't know you. What I want to know is, what have you done, and what are you going to be doing over the next 2 weeks to let the rest of the world know that you exist, that you're a viable candidate, and that you're worth consideration?
I'm going to continue advertising in the ways that I have. The challenge of the election right now is that I came in relatively late, which I think is unfortunate. I think that you ought to be able to not have to be planning 2 years in advance and spending over $100,000 to be effective in a race. And if I had it to do over again, I would have disregarded some of the advice to spend a lot of time pursuing political endorsements. And from day one, just started walking precincts and knocking on doors, because I find that to be the most valuable in terms of interacting and getting a response from folks. And really, those are the people who are going to be showing up and voting. What am I going to continue doing? I'm going to continue walking precincts. This Saturday, I'm having an event in the SoCal area, on Porter Gulch Road, where it's hopefully being widely publicized and people will be able to show up and meet me. Rodeo Gulch, yeah, we can give you the information on that before you leave. I'm picking up another box of 50 signs, and I'm going to continue to distribute those. And I'm going to every event that I can get to. There's going to be some organized door knocking campaigns happening pretty soon, some phone banking. So just your good old fashioned grassroots level political campaigning.
Hope it works.
I hope so too.
Anybody else?
So aside what's required from the legislation, how do you view probation's role in the courtroom and in the community?
Probation is the source of a lot of the information that the judges rely on, and so that's number one. You do investigations into people's background. You make sentencing recommendations. In the juvenile court, probation really drives the whole show, because it's a very front-loaded, fact-intensive, fact-heavy process there. And so, one is to help the court get what is probably the closest to unbiased information for them to rely on. It's not coming from one advocate or another. And in terms of the community, when you ask that question, Gina Castaneda immediately pops into my mind, who is somebody who is just out on the streets working very hard in her role as a probation officer, checking up on her supervisees, and then also very active in a variety of nonprofit activities that are targeted towards rehabilitation and crime prevention for young people. So I think that's a role that probation officers who have the time and the ability to engage in that can do also. There's certainly a community safety aspect of it, because you are supervising people post-sentencing who have certain types of terms, whether it's domestic violence terms or drug terms, things like that. So that's a variety of different roles.
I have two questions, or one with very distinct parts. My first question is, how do you, as a judge, balance the need? I mean, I see court as kind of war by other means, regardless of what the issue is, and how do you balance the need for a victim's, say, sense of vengeance and that justice and retribution are being done with empathy? And those two things, how does a judge balance those two principles when somebody comes before them, say, for sentencing? We're not talking about whether this happened now, but we're talking about how we go forward.
I think that it's probably easy, if you're a judge and somebody comes in and they're, crying, or they're clearly very emotionally upset about what happened, it's probably really easy to give into that and be swayed by that. And I think what you need to keep in mind is I'm not talking about like the vulnerability of the witness, but the reaction or the response of the victim to the crime. Because you have some people, somebody gets their bike stolen, and it's like, oh well, I guess I gotta get a new bike. Somebody else gets their bike stolen, and it's the greatest outrage they've ever endured. And neither one is right or wrong, they're just people reacting the way that they react. But as a judge, you need to look at this and say, okay, well, both these people are equally situated. They had their bike in the side yard of their house. Bike is worth $1,500. It was stolen. Just because somebody is coming in and screaming about their outrage doesn't mean that the defendant in that case should be getting any more severe of a sentence than the person in the other case. It comes down to a bike. It comes down to the other listed out factors in mitigation and aggravation. And so I think you can rely on the law, and also sort of shield yourself with the law by just following the law.
So my next question is that it seems that judicial officers often feel like they have to cloister themselves to some degree from society so that they can make these decisions that they are required to make. What is your opinion on the need of judicial candidates to cloister themselves to some degree from the, all the social goings on, so that they don't create an impression, or that they, I don't know what impression exactly it would create otherwise, but do you understand where I'm going with this? Like the need to remove yourself to some degree so that you can make these decisions from like the black robe perspective?
Sure. So, you don't want to be out, at a bar with your robe unzipped, dancing on tabletops, because obviously you're going to affect the public's trust and confidence in the work that you're doing. When I first got engaged in the race, somebody said, "Oh, say goodbye to all your friends. You're not going to be able to hang out with them anymore."
If you're gonna drink at home.
Which is good advice for anybody, I'd say, right? I don't have any intention of abandoning my friends. My friends in the criminal defense community, it's certainly bound to change the dynamic a little bit. I probably will leave the public defender Christmas party at 9 p.m. instead of midnight. But I think something that I've observed, and I may be way off, but there's a traditional view of, like, people have asked me, aren't you too young to be a judge? And there's a traditional view of judges that you put a full career's worth of time into your law practice, and then getting to the bench is like this final accolade, this final accomplishment to finish off your career. And I think that mindset and that approach creates this sort of ivory tower type of perception of the court. I think that one of the roles of the judiciary is to be available, not to be persuaded by the public, but to be aware of the concerns of the public. Potentially share information about what's going on at the ground level in the trial courts, so that people in the community can feel confident that good work is being done on their behalf, that the concerns of public safety and public health are being adequately addressed. But I would take a step back and say my perspective in terms of pursuing this position, I am not driven by ambition. Okay, I am driven in this case by a sense of obligation. Santa Cruz County, my home for my entire life, has been tremendous to me. I've had a great experience here. And I've been able to have a fantastic career for the last 10 years in the public defender's office, where I've developed a skill set that's going to allow me to take the bench in any one of those departments and be fair and be efficient with county resources and time. And I feel, given the great benefits and the great advantages I've had in my life, I have an obligation to pay that back in some way. So now I can take those skills that I've developed and I can fulfill that obligation in this role. So it's not ambition, it's obligation for me.
Jonathan, one of the things that, and if I might step in here, in regard to your concern about, I think your concern is the perhaps too strong an impact of an emotional victim at a sentencing, or even worse, the emotional victim's parent at a sentencing. I teach that what judges should do, I teach criminal procedure in Santa Cruz, is if you have a relatively high exposure sentencing, is you want to make sure that the participants understand that they need to get their written materials to you, to the court, not to, prior to the hearing. Because if you anticipate a highly emotional, lengthy sentencing, what you've done, in my opinion, if you've done it right, is you have it written out, outlined step by step before the hearing starts. So that you have the material to do that, so that you can make an unemotional decision as to what state prison, not state prison, very common and important decision. Aggravated term, not aggravated term, consecutive, concurrent, those types of decisions. You want to have made your decision in advance so that you are not overwhelmed by a weeping mother, okay? I learned early on that I could be overwhelmed by weeping mothers, okay? So you do that in advance. That doesn't mean you're disregarding the people that are speaking, although sometimes you want to. But if something new comes up, it has to come to your attention. Whoa, I didn't realize that was going on. So as advocates, you have to understand that you want to have your best stuff, your best material presented in writing to the court and through a sentencing memorandum of some type. And don't hope that you're going to spring something on the court with the sentencing that is going to cause the judge to change this detailed script that has already been prepared. Okay. So
Zach, I've never met any of your detractors, but assuming such a person exists, how would you respond to hypothetical concerns that, coming from the public defender's office, you would bring a bias to the bench in a way that someone who, for instance, had never practiced criminal law would not bring? Do you understand?
Am I going to be too lenient because I'm a public, or?
Well, assuming I'm a swing voter, I'm on the fence, and I'm thinking, I like what Zach Schwarzbach has to say, but I'm afraid that as a 10-year public defender, is he going to be tough on crime the way many people think judges need to be? Or how do you see that? How do you see your role in relation to that, potential question from a hypothetical detractor?
What I told the DAs on Monday night is that I've probably sent more people to prison than most of the people who showed up to watch the front as a public defender. I think there's a wing. I think it's the Minslav Schwarzbach wing. It's the same wing. I don't mean to make light of people going to prison, but I didn't become a public defender because I like crime or because I want the community to be less safe. I live here. I think that's an important factor to consider. My children are growing up here, and I'm going to take each case on its own. I'm going to review the law. I'm going to follow the law, and certainly if I'm doing things that are outrageous, terms up in 6 years, they could run somebody against me. But I don't think that needs to be a concern that anybody has. And back to my campaign materials, I've used the word compassion in my campaign, and certainly as a public defender, I've developed the skill to be able to sit down with just about anybody I've ever worked with, representing, regardless of how serious or heinous the behavior, and identify and recognize some modicum of humanity in those people. But it doesn't stop there. My compassion is not just for the accused. My compassion is for people who've been hurt, right? For family members who've lost loved ones, for people who are struggling with addiction, for people who are concerned about the quality and the character of their communities. And so I'm equal access. I gotta figure some clever turn of phrase here. My compassion doesn't just go to one community of people. It's for anybody.
Elizabeth, do you have a question back there?
Yes, Zach, can you name 3 judicial officers who you admire or you look up to in terms of your pursuit of the bench?
Yeah, you probably should leave out the local judiciary.
Okay.
No, you need to leave out.
Including your
I don't know that. One it would be Chris Rudy, he's actually a family friend. He's a judge in Santa Clara County, and he's been a mentor to me since I was in college. He helped me through the law school application process, and he was a trial attorney before he took the bench. Incredibly nice man. Has been a great resource for me to go to and talk to. Before I threw my hat in the ring, I went to him, had lunch, and asked him, what's it like? What's the experience like being a judge? Are you happy you made the transition from being a trial attorney to doing it? And he is somebody who actually got to go and watch him in court. He's doing family court in Santa Clara County, and watch his demeanor and watch his ability to interact with people. And I really admire that he treats people respectfully. He has to deal with emotional people, emotional parties, and he is able to let them feel heard. They go in there and they leave. I believe probably for the most part that their voice has been heard, but also then ultimately do what he needs to do.
If you can't come up with others, that's okay.
I gotta go Ruth Bader Ginsburg. She's great. I can't think of anybody else offhand. There's certainly local judges that I do have a tremendous amount of respect for. I don't know.
I have spoken to your detractors, and those that criticize you in response to what you said. And I noticed that the highest and strongest criticism they have been able to come up with so far, and which you probably should address, is you've spent your entire career as a public defender. Our court, only one portion of it is criminal law. What about the lack of civil experience? Your opponent is trumping up and accelerating her virtues as being adept in all aspects of the civil arena. And she repeatedly points out, while she's gently putting this out, that you have none. And so I guess the question for those who are curious about your critics is, how are you going to respond to your lack of civil experience to show us that you are still a better candidate than your opponent, who claims to have all this experience in all these areas, all the time, everywhere, always?
Not only do I have more trial experience than my opponent, I actually have more civil trial experience than my opponent. During my career as a public defender, one of my first assignments was working on Lanterman Petra Short Act hearings, and that is mentally ill adults. If the public guardian's office of the county wants to conserve them, basically take over managing where they live, how they pay their bills, how they get their treatment, there's a process that has to happen, and I've represented people in that process. That is a civil process. I'm one of the few attorneys practicing in the county who's actually done a 1368, which is competence to stand trial, jury trial. That is a civil commitment. The rules of jury selection from civil law apply. It's a civil standard, and so my opponent cannot say that she's done a civil jury trial. I've done that. I've done a not guilty by reason of insanity jury trial. Again, a civil commitment. Civil rules apply to the process there. I've worked on sexually violent predator cases, which is a quasi-civil criminal type of hearing. For example, discovery is covered not under the Penal Code, Section 1054. It's actually covered under the rules of civil procedure for discovery. So I'm familiar with that. And as a practitioner at the trial court level in local courts, there's sort of a theme that goes across, that runs through every courtroom, and that is notice, response, and then some mechanism for resolving the dispute. And there's little nuances here and there are variations on what exactly type of mechanism applies, but that's due process, whether it's for a criminal defendant or a civil litigant. That process is ultimately, for the most part, what controls. The difference is which code book are you cracking to make sure you're up to speed on the most current versions of the law. And that's something I absolutely have the ability to go and do. And any judge, when they get a new assignment, is going to get trained up on that assignment. And they're going to make themselves masters of that area of law so that they can do good work. And I certainly will do that. So my opponent can tout whatever experience she wants. The fact is, I'm the one with local court trial experience, the only one.
Very good.
Anybody else? Okay, you want to add anything in summation, or you feel like you're preaching to the crowd too much here, or what?
I have a couple things I want to say.
Go ahead.
Yeah,
Go ahead.
absolutely.
I can criticize some more if you want.
You've had enough today.
Thank you.
So what I would like to finish by saying is that, if I get on the bench, neither side, it's kind of funny to refer to it that way, but prosecutors, criminal defense attorneys, people coming in through civil process, what they can count on is that I am going to treat people fairly, that I'm going to listen, that I'm going to work hard to make sure that their efforts are recognized and treated with due regard. And I know that I can do that because I have been one of the people on the ground level for the last 10 years, prepping my cases, coming in and doing that work. And while civil or criminal courts only make up a portion, they make up actually the largest portion of our courts. Most jury trials come out of the criminal courts. And the rules on jury selection are constantly in flux, but the state of them currently is that misdemeanor cases and civil cases, you get only 6 peremptories. I know that oftentimes in misdemeanor courtrooms, the attorneys are getting about a minute to a minute and a half per potential juror. And so ultimately, juries are being chosen by the judge. Most of the jury selection is being done by the judge. And I don't think that it's fair for the first jury a person picks to be in a case that they're presiding over. What I can do is I can bring my skill set as a trial attorney and make sure that everybody's getting a fair process and an efficient process. The other issue I want to address is that much has been made about the fact that I am a white man running against a woman. If there is anybody here or anywhere who thinks that putting me on the bench is going to perpetuate some sort of patriarchy or some sort of good old boy environment in that courthouse, they do not know me at all. I am very fortunate to be a part of a generation where I was born day one and raised with the teaching and the belief that women are my equals and very oftentimes my betters. I have a daughter and I have 2 sons, and I'm proud to be teaching my daughter to be independent and strong, and I'm proud to be teaching my sons to be respectful of women and treat them with the respect they're entitled to and as their equals. You have nothing to fear from putting a white man on the bench when it comes to me. I will treat everybody who comes before me equally and fairly. And if you guys are interested in supporting me, please let me know and spread the word. Tell your neighbors, tell everybody that lives around you, tell everybody you work with. The word has to get out. There's time. There's 3 weeks left. You can win this thing with your support.